5 seconds to go. Start. The purpose behind the enactment of Section 197 CRPC must not be to shield corrupt officials, and this was the position taken in Inspector of Police and another versus Batain Patala Venkata Ratnam and another, reported in 2015-13 SCC 87. Here, the respondents, while working as sub-registrars in various offices of the state of Andhra Pradesh, had conspired with stamp vendors, document writers, and other staff to manipulate the registers and had gotten the documents registered with the old value of the respective properties, resulting in wrongful gain to themselves and loss to the government. Such acts were held to not be in the discharge of their official duty. The observations made are reproduced herein below. The alleged indulgence of the officers in cheating, fabrication of records, or misappropriation cannot be said to be in discharge of their official duty. Their official duty is not to fabricate records or permit evasion of payment of duty and cause loss to the revenue. Unfortunately, the High Court missed these crucial aspects. The learned magistrate has correctly taken the view that if at all the said view of sanction is to be considered, it could be done at the stage of trial only. This court in Surinderjeet Singh Mand and another versus State of Punjab and another, reported in 2016-8 SCC 722, was faced with a factual scenario wherein an accused was allegedly arrested in a theft case by the appellant police officers on 24th June 1999, but was formally and officially shown to have been arrested only on 28th June 1999. Prosecution was initiated against the appellant officers on the basis of an FIR registered at the instance of the mother of the accused in relation to the alleged illegal detention of the accused for the period from 24th June 1999 to 28th June 1999. While holding that no sanction to prosecute was required in the circumstances of an illegal detention, this court observed as thus: having given our thoughtful consideration to the contention advanced at the hands of the learned counsel for the respondents, we are of the view that the decision rendered by this court in PP Unni Krishnan case, it is clear and emphatic. The same does not leave any room for making any choice. It is apparent that the official arrest of Neeraj Kumar in terms of the provisions of the code referred to herein above would extend during the period from 28th June 1999 to 30th June 1999. The above period of apprehension can legitimately be considered as having been made while acting or purporting to act in the discharge of their official duties. The factual position expressed by the appellants is that Neeraj Kumar was not detained for the period from 24th June 1999 to 28th June 1999. His detention during the above period, if true, in our considered view, would certainly not emerge from the action of the accused while acting or purporting to act in the discharge of their official duties. If it emerges from the evidence adduced before the trial court that Neeraj Kumar was actually detained during the period from 24th June 1999 to 28th June 1999, the said detention cannot be taken to have been made by the accused while acting or purporting to act in the discharge of their official duties. More so because it is not the case of the appellants that they had kept Neeraj Kumar in jail during the period from 24th June 1999 to 28th June 1999. If they had not detained him during the above period, it is not open to anyone to assume the position that the detention of Neeraj Kumar during the above period was while acting or purporting to act in the discharge of their official duties. Therefore, in the peculiar facts and circumstances of this case, based on the legal position declared by this court in P.P. Unni Krishnan case, we are of the considered view that sanction for prosecution of the accused in relation to the detention of Neeraj Kumar for the period from 24th June 1999 to 28th June 1999 would not be required before a court of competent jurisdiction takes cognizance with reference to the alleged arrest of Neeraj Kumar. We therefore hereby endorse the conclusions drawn by the High Court to the above effect. Thus, the legal position that emerges from a conspectus of all the decisions referred to above is that it is not possible to carve out one universal rule that can be uniformly applied to the multivarious facts and circumstances in the context of which the protection under Section 197 CRPC is sought for. Any attempt to lay down such a homogeneous standard would create unnecessary rigidity as regards the scope of application of this provision. In this context, the position of law may be summarized as under. The object behind the enactment of Section 197 CRPC is to protect responsible public servants against institution of possibly false or vexatious criminal proceedings for offences alleged to have been committed by them while they are acting or purporting to act in their official capacity. It is to ensure that the public servants are not prosecuted for anything which is done by them in the discharge of their official duties without any reasonable cause. The provision is in the form of an assurance to the honest and sincere officers so that they can perform their public duties honestly to the best of their ability and in furtherance of public interest without being demoralized. The expression any offense alleged to have been committed by him while acting or purporting to act in the discharge of his official duty in section 197 CRPC must neither be construed narrowly nor widely, and the correct approach would be to strike a balance between the two extremes. The section should be construed strictly to the extent that its operation is limited only to those acts which are discharged in the course of duty. However, once it has been ascertained that the act or omission has indeed been committed by the public servant in the discharge of his duty, then a liberal and wide construction must be given to a particular act or omission so far as its official nature is concerned. It is essential that the court, while considering the question of applicability of section 197 CRPC, truly applies its mind to the factual situation before it. This must be done in such a manner that both the aspects are taken care of, viz. On one hand, the public servant is protected under section 197 CRPC if the act complained of falls within his official duty, and on the other, appropriate action be allowed to be taken if the act complained of is not done or purported to be done by the public servant in the discharge of his official duty. A public servant can only be said to act or purport to act in the discharge of his official duty if His act is such that it lies within the scope and range of his official duties. Stop.